The Sullivan Act is a gun control law in New York State that took effect in 1911. The law required licenses for New Yorkers to possess firearms small enough to be concealed. Possession of such firearms without a license was a misdemeanor, and carrying them was a felony. The act was named for its primary legislative sponsor, State Senator Timothy Sullivan, a notoriously corrupt Tammany Hall politician. For handguns, the Sullivan Act qualifies as a may-issue act, meaning the local police have discretion to issue a concealed carry license, as opposed to a shall-issue act, in which state authorities must give a concealed handgun license to any person who satisfies specific criteria, often a background check and a safety class. History. The law resulted from political pressure on prominent New Yorkers, including Sullivan, in the form of letters and recommendations from George Petty L. Brunn, who worked in the city's coroner's office, after a brazen early afternoon murder-suicide near Gramercy Park. The law went into effect on August 31, 1911. In addition to handguns, the law prohibits the possession or carrying of weapons such as brass knuckles, sandbags, blackjacks, bludgeons, and bombs, as well as possessing or carrying a dagger, dangerous knife, or razor with intent to use the same unlawfully. Violation of any of the prohibitions is a felony. According to Richard F. Welch, who wrote a 2009 biography of Sullivan, all the available evidence indicates that Tim's fight to bring firearms under control sprang from heartfelt conviction. Sullivan's contemporaries disagreed with this assessment and saw the law as disarming lawful citizens or as a way for Sullivan to guarantee his bodyguards could be legally armed while using the law against his political opponents. Lawman Bat Masterson, a friend of Sullivan's, criticized the law as obnoxious and said that he questioned Sullivan's mental state of mind over the law. New York City license holders. In New York State, apart from New York City, the practices for the issuance of concealed carry licenses vary from county to county. In New York City, the licensing authority is the police department, which rarely issues carry licenses to anyone except retired police officers, or those who can describe why the nature of their employment, for example, a diamond merchant who regularly carries gemstones, or a district attorney who regularly prosecutes dangerous criminals, requires carrying a concealed handgun. Critics of the law have alleged that New Yorkers with political influence, wealth, or celebrity appear to be issued licenses more liberally. The New York Post, the New York Sun, and other newspapers have periodically obtained the list of licensees through Freedom of Information Act requests and have published the names of individuals they consider to be wealthy, famous, or politically connected that have been issued carry licenses by the city police department. Controversy. Some question the constitutionality of the act, due to the Second Amendment of the U.S. Constitution. While the Supreme Court has only recently ruled that the Second Amendment prevents localities from enacting outright handgun bans, see incorporation, the question of whether the Second Amendment provides grounds to invalidate local gun control laws like the Sullivan Act may be addressed given the 2008 Supreme Court case District of Columbia v. Heller affirming the decision by the United States Court of Appeals for the District of Columbia Circuit in Parker v. District of Columbia. Other critics have argued the arbitrary nature of the law violates New York State Constitution protections of due process and equal justice. The New York court system holds the Second Amendment as inapplicable to the states. Many believe the intent of the act was to discriminate against immigrants in New York, particularly Italians, as the first person convicted under the law was an Italian immigrant named Marino Rossi who was traveling to a job interview and carrying a revolver for fear of the Black Hand. At sentencing the judge declared, "It is unfortunate that this is the custom with you and your kind, and that fact, combined with your irascible nature, furnishes much of the criminal business in this country." Prior to Marino's arrest, others had been arrested under the new law but were released without charges. Whether this was part of the law's intent, it was passed on a wave of anti-immigrant rhetoric as a measure to disarm an alleged criminal element. The police department who granted the licenses could easily discriminate against undesirable elements. Days before the law took effect, the New York Times published an article saying low-browed foreigners bargained for weapons of every description and gloated over their good fortune in hearing of the drop in the gun market before it was too late. After Rossi's conviction, the New York Times called this warning to the Italian community both timely and exemplary. According to New York City historian George Lankovic, the act was passed so that Sullivan could have friends in the police force plant handguns on his rivals and take them to jail. Statistics showed that after the act passed that gun murders in New York City rose 18%. The city first tabulated murders in 1928, when it had 404. By 2016, despite a much larger population, the city suffered 335 murders. There are a number of alternate explanations for this, though, including improved medical technology allowing more gunshot victims to survive and increased prosperity reducing gang membership. Cano Youngs, Zelen, Calvert, Scott, Gay, Mara, January 4, 2017. New York City major crimes fall to lowest recorded level. The Wall Street Journal. Retrieved January 6, 2017.
Please subscribe and thanks for watching.